Hello, and welcome to the Number 5 Planning Podcast. I'm Daniel Henderson, and you rejoin us today after a summer break to discuss the topic that is on everyone's lips, the judgment of the Supreme Court in C.G. Fry. It's a judgment we've been waiting for some considerable time, handed down last week, and is one of the few high-profile judgments we've seen in recent years where all parties are claiming at least partial victory. I am today joined by James Corbet Burcher and Chatura Saravanan, planning and environmental barristers at Number 5 Chambers, to assess the veracity of those claims. We're going to look at the judgment itself in some detail and have a look also at the key practical implications and takeaways from the judgment, both in terms of the habitats regulations point, but also more generally in terms of the Supreme Court's commentary on what an outline planning permission actually is and how the planning system works as a whole. And I'm going to begin just by explaining the background to the case. So I think it's worth starting by just reminding ourselves how we got here, because it's been a long old journey stemming back to an application from, I think, 2021. We're concerned here with a mixed-use development in Somerset, for which outline permission was granted in 2015. Reserve matters approval was then obtained for Phase 3, which was a residential aspect, 190-odd dwellings, in June 2020. Shortly thereafter, Natural England published its now very well-known note following on from the Dutch nitrogen case, advising local authorities, advising Somerset in particular, to have particular regard for phosphate levels in the Somerset Levels and Moors Ramsar site, and advising the council to undertake appropriate assessments and only grant consent if it was ascertained that the development would not have an adverse effect on that site. And as an important marker there, we are dealing only with a Ramsar site here, not a European site more generally. That'll become important down the line. In 2021, the developer then put in an application to discharge pre-commencement conditions in relation to Phase 3. Somerset Council refused to determine that application on the basis that they said an appropriate assessment was required in line with Natural England guidance. The developer disagreed, so it all went off to the Secretary of State, and an inspector agreed with the council and determined that Regulation 63 of the Habitats Regulations also applies, or can also apply, at discharge of conditions stage, and dismissed the appeal. The challenge was then brought in the High Court on the basis that the inspector had misinterpreted the Habitats Regulations, or alternatively, that if you could require an appropriate assessment at discharge of conditions stage, the scope of it should reflect the scope of the conditions being considered. The High Court dismissed the claim on both grounds, and it's worth just understanding a bit about the reasoning and the basis upon which the High Court did so, because the High Court, unlike the two higher courts, relied heavily on EU law and relied heavily on the Habitats Directive, which is the source of the Habitats Regulations in domestic law. So Sir Ross Cranston, who was the judge in the High Court, went into great detail on all those topics we're very familiar with from pre-Brexit, direct effect, on the withdrawal agreement, on the effect of Brexit, and what that meant for interpreting domestic legislation. The High Court concluded that Article 6.3 of the directive, which focuses on circumstances in which a project is, quote, agreed, and derived from that that an appropriate assessment can be undertaken at the very end of a lengthy multi-stage consenting process, because that is the point at which the project is agreed. That's the point at which it's given the green light. On appeals to the Court of Appeal, they dismissed the appeal, but taking a slightly different approach and with a slightly different emphasis. And that'll again become important later, because the Court of Appeal relied very heavily on the domestic position. And they concluded that as a matter of basic statutory interpretation, Regulations 63 and 70 of the Habitats Regulations permitted appropriate assessments to be carried out at discharge of conditions stage. And they referred to the phrase any consent, permission, or other authorisation, which is the relevant decision-making stage in Regulation 63. The Court of Appeal held that was clearly pretty broadly drafted, and bearing in mind the importance of purposive interpretation in light of the purpose of the directive to afford a high level of protection to protected sites, it was clear that on basic statutory principles, appropriate assessments can be carried out at discharge of conditions stage. They also addressed an argument, which again, to set down yet another marker, became important in the Supreme Court, concerned what was then NPPF paragraph 181 and is now paragraph 194. And that's the paragraph that requires that certain matters, including Ramsar sites, be given, quote, the same protection as habitats sites. That was an argument that didn't get much shrift in the High Court. The Court of Appeal also dismissed it. The argument that was put by the developer was that the government wasn't entitled, by virtue of the NPPF, to make legally relevant matters which were legally irrelevant under the habitats regulations. So the HABS regs are clear about what needs to be assessed. It doesn't include Ramsar sites. The government is not entitled to add Ramsar sites into the mix by way of policy, so the argument went. And the Court of Appeal held that that wasn't right, that there was nothing wrong with the Secretary of State exercising her broad power to make policy, to afford equivalent protection to Ramsar sites. It's an interesting point which was put slightly differently in the Supreme Court, as we will see. The case then went off to the Supreme Court with two grounds of appeal. First of all, the big issue, the headline issue, that regulations 63 and 70 of the HABS regs only permit or require appropriate assessments to be carried out at initial grant of planning permission. And secondly, that NPPF 181 could not lawfully include Ramsar sites in respect of an appropriate assessment by a sort of policy backdoor. Chatura, can I ask you then to take us through what the Supreme Court did decide on those two issues?
Thank you, Daniel. And yes, beginning with the first issue on the interpretation of the habitats regulation, the Supreme Court essentially agreed with the Court of Appeal in saying that no matter how you look at it, whether you're giving the habitats regulation either a purposive interpretation or you're looking at the natural and ordinary meaning of the words, it's clear that Regulation 63 gives the powers to require appropriate assessment at any stage, not just at the stage of the grant of planning permission. Similar to the Court of Appeal, they relied on the wording in Regulation 63 in particular, and specifically the words that go to the effect before deciding to undertake or give any consent, permission, or other authorization for a relevant plan or project. So essentially, the Supreme Court said that it's a deliberately broad provision, and so there's no basis for reading into a restriction that you can only require appropriate assessments at the stage of grant of permission and not at any later stage. That was really what the court said under ground one. When it came to ground two, however, the Supreme Court decided to take a different view to the Court of Appeal. Mainly, they said that the Court of Appeal erred in coming to the conclusion that paragraph 181 of the NPPF, as it then was, has the same status as the legal rule set in legislation. So what the Supreme Court said was, you can only take into account material considerations when making a decision, whether that's a decision to grant planning permission or whether that's a decision to discharge planning conditions. In this case, the Supreme Court ruled that paragraph 181 was not a material consideration for the purpose of the discharge applications. For example, in this case, one of the conditions which hadn't been discharged was a condition to do with tree protection schemes. And the Supreme Court said, well, it's just not a relevant consideration for the purposes of a tree protection scheme, whether or not the application or the proposal will comply with paragraph 181. And in doing so, the Supreme Court also noted that when planning permission is granted, whether that's a full planning permission or an outline planning permission, there's a fundamental change in the legal position. That is, the developer now has a right to develop the land in accordance with the permission, subject to the conditions attached to it. And so once that right has been secured, then it cannot be taken away or diluted by policies laid down by the central government. And this is where all the discussion about costs incurred and what a developer or indeed any person with planning permission can rely on. Essentially, the court said a developer should be able to proceed with the development of a planning permission without fear of a change in position by the regulating authority. Now, when it comes to discharge of conditions, as was the case here, the considerations for the LPA should have been only those fairly related to the subject matter of the conditions themselves. And in this case, the court ruled that paragraph 181, i.e. impacts on Ramsar sites, were not relevant. I think the key takeaway from this second ground is, putting aside the question of Ramsar sites, is whether or not or how one can conclude what is and is not a material consideration, especially at discharge of condition stage. So the Court of Appeal had said, well, paragraph 181 is a material consideration because if the LPA were to ignore it and discharge the conditions, then they would be at risk of being in conflict with paragraph 181 of the NPPF, and therefore paragraph 181 is relevant. But the Supreme Court disagreed and said you need more than just an argument to say if you didn't take into account this policy, then you'll be in conflict of it, to say that something's a material consideration. So you need a more direct connection between the subject matter of the condition and the policy in order for that policy to then become a material consideration. So that's, I think, a really interesting takeaway from the court's judgment under the second ground. I'm sure it will be something that a lot of legal arguments will span out of as to whether or not something is a material consideration at discharge of condition stage. Now, of course, this is all decided with regards to Ramsar sites. The Supreme Court says it's different when it comes to European sites, i.e. those sites protected by the habitats regulations, because there's a legislative provision, i.e. the habitats regulations, which does make it a material consideration to take into account the impact on the European sites. And so it's different for European sites, but with regards to Ramsar sites, because the Ramsar sites aren't protected by legislative provisions, they don't have that same effect. And so that's really where the Planning Infrastructure Bill, I'm sure, will make a big difference. And I hope that's given a good lead into talking about those next points.
It has, yeah, thank you. It's that last point that's the really interesting one, isn't it? And we'll come on to talk about it in a minute. The point that the Supreme Court makes in paragraph 60 about the difference between a legal rule set out in legislation and a statement of policy, and what those two categories are and whether they're as distinct as they might appear to be. Looking then at some of the more practical implications of it, James, obviously the key issue, the headline issue with which we're principally concerned is the clarity that we've now got on the circumstances in which an appropriate assessment can be triggered. And we know now, certainly, don't we, that an appropriate assessment can be required at discharge of conditions stage. But what's probably interesting is the way in which the Supreme Court went about it, the purposive interpretation that they gave the regulations, and the importance that they gave, particularly around sort of paragraph 50 of the judgment, to the protective nature of the regulations.
Yes, Daniel, I agree. If you're looking for paragraphs in this judgment, they're going to be much cited at inquiry and potentially, happily or not, in court. I would certainly look to paragraphs 50 and 51 as a starting point, where it's emphasised that the European case law that's been reviewed earlier needs to be interpreted in light of the precautionary principle, and that aims to give vulnerable sites a high degree of protection. And the next paragraph says that the purpose of the habitats regulations, the domestic regulations, is to implement and follow the Habitats Directive and pursuing the same objective. Brexit has made no difference to this. And so the point of law, it's perhaps not hugely controversial, but it is that the European case law, respect to precautionary principle, remains relevant. High degree of protection or other strict protections remain vitally important. And so the courts are going to interpret existing retained European legislation in the light of those.
Yeah, absolutely. And those paragraphs, I suspect, will be often quoted if there is further litigation on some of the issues that are sort of related to but not quite dealt with by C.G. Fry. So it's obviously important to remember the conclusion of the inspector that was under challenge was that the habitats regulations permitted an appropriate assessment to be carried out at discharge of conditions stage. What was not under challenge was anything about when it should be, or in what particular circumstances an appropriate assessment would be necessary at discharge of conditions stage. So one can imagine a situation with a lengthy multi-stage consent process where, for example, an appropriate assessment was carried out at the point at which outline permission was granted. Many years down the line, whether there's been some scientific development or some policy development that renders that appropriate assessment out of date, the question might then be asked, well, is there a requirement under Regulation 63 to do it all over again? In circumstances like that, one can see very much how the Supreme Court's clear statement, Brexit has made no difference to this, and its constant reference to the high degree of protection that the HABS regs provides could be directly relevant.
Absolutely. Precautionary means precautionary, and those engaged in such schemes need to just give real thought to what paragraphs 50 and 51 are saying at Supreme Court level for the habitats regulations and the variety of issues which may arise under those, but perhaps also for questions in respect of EIA and SEA, where those engage questions of protections of the environment as well.
Yeah, absolutely. And there's a bit of discussion about the overlap between the case law earlier on in the judgment. Chatura, you mentioned in the discussion of Ramsar sites, if we just sort of hone in on the Ramsar issue specifically, that while on the face of it, this may seem to be a storming win for CG Fry, as far as Ramsar is concerned, it may not be a win that lasts all that long because of the Planning and Infrastructure Bill. Can we just an update with what's going on with that and what effect that might have on the judgment?
Yes, so the Planning Infrastructure Bill not yet received royal assent, but as we understand it to be imminently coming forward, that bill seeks to essentially introduce Ramsar sites into the habitats regulations. So whatever protections the European sites receive, the same protections should be given to the Ramsar sites. That would, of course, seem immediately that the effect of CG Fry is short-lived. However, a broader picture that we should probably bear in mind is that the Planning Infrastructure Bill as a whole seeks to bring forward a whole host of changes with regards to how we deal with environmental impact assessments and other types of assessments. And so it seeks to introduce what's in short form called EDPs, and potentially a way for developers to contribute to EDPs and to the natural England in the form of a nature restoration levy, which could then mean that they don't need to carry out any site-specific assessments for their proposals. And so the whole question of appropriate assessments and when they are going to be needed to be carried out is potentially under question and subject to change depending on what comes as a result of the Planning and Infrastructure Bill. But EDPs aside, if the infrastructure bill was to come forward, receive royal assent, then Ramsar sites will gain the same legal status in terms of the protections that is afforded to those other sites in the habitats regulations.
Yeah, absolutely. So it's clause 93 of the bill as it presently is. And you're right to say, I mean, effectively, if that comes forward, it would reverse the Supreme Court on ground two. It would put Ramsar sites on that legislative footing, put them in that rule of law contained in legislation that the Supreme Court talks about in paragraph 60. And that, James, doesn't it, leads into another interesting point that comes out of the judgment, which is the paragraph I highlighted earlier, paragraph 60, and the delineation between a statement of policy and a legal rule set out in legislation, which on one view seems to draw a very clear line, doesn't it, according to the source of the obligation, whether it's legislative or policy. What do you make of that?
Yes, I think it's a really interesting point, bearing in mind the powers now available under the Levelling Up Regeneration Act, the LAURA, to put national policy NDMPs on a statutory footing. This is another aspect in which the current government's legislative changes are creating a new platform in which to look at all these issues. And one could see a scenario if the NDMPs were to be brought forward with statutory status, that there would have to therefore be quite careful drafting to consider what the impacts of such NDMPs would be at this stage. And indeed, it may also have a bearing on how the government chooses to implement those parts of the legislation in respect of whether it will go for a full-fat version of the NDMPs with full statutory status, or has begun to be hinted something which falls slightly short of that and which retains more of the flexibility of the current NPPF. So, it's really interesting. A lot of these judgments at the moment are snapshots in time, arguments some time ago in court, judgment comes out later, legislation underfoot at that point, and of course other consultations going on. So another example of how it's just at the moment it's a constant process of change at all levels of the planning system.
Yeah, absolutely. And it's interesting, isn't it, to set it side by side with Mead in the Court of Appeal from the start of the year, which we did a podcast on, and James and I had a chat about, where the emphasis was very much on the very wide discretion the Secretary of State has to organise planning policy in any way they may see fit. Set that against here, where inclusion in national policy was found to be insufficient on the basis that it wasn't on a sufficiently legislative footing. The NDMP's point is an interesting one in terms of whether, I mean, in a putative world, an NDMP came out with one paragraph saying Ramsar sites are to be treated the same as European sites, whether that would have made any difference to the outcome. For my part, I think there is the nub at the heart of the Supreme Court's judgment, although it's sort of expressed as a difference between legislation and policy, is actually about the way in which the habitats regulations work, and that it sits adjacent to but outside the planning acts, that it's a freestanding legal obligation that is quite detailed, that is quite carefully staged to conduct appropriate assessments at particular points. And that even if you have an outline planning permission that grants you the bundle of rights that the Supreme Court referred to, that doesn't oust the fact that there are still separate freestanding duties on authorities under the habitats regulations to conduct assessments if they're required.
Yeah, I think what's really interesting here is an underlying concern on the part of the Supreme Court about that extent of transparency or finality which currently attaches to national policy. And by contrast, a world in which there is a much clearer statutory scheme, at least to introduce the NDMPs, and then carefully to consult on any changes to them, and then introduce revisions of that, might well have shifted the balance a bit in a case like this. But of course, also gives those authoring the NDMPs and publishing them quite a lot to think about prior to that first publication.
Yeah, very much so. The final interesting topic then that I think comes out of CG5, for what that's worth, is the reinforcement of a principle that is as old as the planning system, but no less important for it, which, Chatura, you touched upon in your summary of the judgment, which is what do you get when you get an outline permission? And what can the local authority do when discharging conditions, or indeed dealing with application for reserve matters approval, by way of seeking to control matters that have already been dealt with? And the interesting point here, I think, is the way the Supreme Court puts it, because it's an issue that's often been described in quite technical terms. Listeners might be familiar with ludicrously named cases like I'm Your Man, which touch on the question whether you can control by conditions matters which were not dealt with at outline stage or even at full stage. It'll be nice to ditch the reference to I'm Your Man, if nothing else, as a slightly ludicrous way of referring to that principle. But the Supreme Court deals with it in a much more normative way, doesn't it? It talks about the bundle of rights that you can expect to get as somebody, a developer, looking to bring forward development within the planning system that we have in this country.
Yes, absolutely, Daniel. The court's focus on it is on the interaction between public interest and private rights. And so the court says once you, as a developer, or indeed as any planning permission holder, gains those rights having been granted planning permission, you should be able to expect to build out on the basis of that planning permission, provided you, of course, comply with the conditions which are set out in the planning permission. And if the local planning authority wants to, as a result of change in national policy or as a result of scientific evidence that's come to light, wants to then reverse that planning permission and wants to bring into question again the principle of development, then it can only do so by revoking that permission, and thus then engaging the compensatory measures that come into place via the Town and Country Planning Act. So again, the court is focused on how private rights can be impacted by public decision-making and public policy-making as well, and making sure that developers and planning permission holders' rights are not thrown away without the necessary compensation being provided for it.
Yeah, absolutely. And of course, although here we were dealing with an outline planning permission and reserve matters, it's all the same set of principles because, we know that an outline planning permission, even though in practical terms an outline planning permission and a full planning permission look very different, in terms of the rights that you obtain as a result of an application being granted, they are still a planning permission. Both are planning permissions. And we know that an outline permission is just a grant of planning permission subject to conditions relating to reserve matters being approved in due course. James, just to finish, another interesting paragraph that I can see being quoted all over the place in appeal decisions and courts is at the end of 66, when considering the circumstances in which local authorities can consider matters that might not be said to be squarely related to the condition of which discharge is sought, is the phrase fairly related to that subject matter. And Lord Sales refers to the imposition of a condition that the planning authority has agreed to a scheme for tree protection is confined to consideration of matters fairly related to that subject matter. That has the potential to be perhaps a slightly slippery phrase.
Yeah, I think there is a risk of some suggesting that conditions therefore can be quite open-ended, can have quite a general condition, setting out that one could simply bring forward a variety of important matters through simply LEMPs, that sort of thing, as long as obviously the matters are fairly related to that subject matter as covered in the wording condition. And there'll be debates about how prescriptive you should be about conditions, particularly where there is something specific which the local authority wants. It may be argued on the other side that that wording is open enough to allow all these matters to be dealt with in the future. And to an extent, one doesn't want to push that element of the judgment too far. Consideration of matters very related to that subject matter. This is, as we can see on the facts of this case, is dealing with something that's been crystallised, which obviously in that case the scheme for tree protection, all the rest of it has been settled. I think actually the reverse is, still if there are important matters and they obviously meet the tests, I think inspectors are going to be encouraged, perhaps persuaded by LPAs, to put in wording that's more prescriptive, rather than just simply say, well, it can all be dealt with at that latter stage. So yes, I think something to watch out for, paragraph 66, future debates on the content of conditions, what could be dealt with at the detailed stage.
Yeah, absolutely. And I suppose that raises the interesting specific question in terms of Ramsar, because in a world in which one of the conditions that CG Fry sought to discharge was, for example, something to do with foul water drainage, which directly affected phosphates, there's no reason in principle on the face of the Supreme Court's judgment that impact on the Ramsar site could not have been taken into account as part of that discharge of conditions assessment, because were it to be appropriately part of the policy background, there's no reason to say that it wasn't relevant to that. That doesn't mean to say that an appropriate assessment was required, but it does mean that it could, in theory, still be a relevant consideration on the right facts if the discharge of condition in question might affect a Ramsar site.
Yeah, I think there's a really interesting point emerging from all of this in the light of that new legislation being brought in place to provide that protection to Ramsar sites. This question of are the courts helping developers in the context of a real zeitgeist moment under the current government to build many more homes, unlock the planning system, make it more simple. I suppose it was certainly, this judgment has been presented as being very helpful for the broader development industry. I wouldn't wish to accuse this government of being unhelpful. That certainly isn't the policy position. But at the same time as one has a judgment which unlocks, we obviously have the legislative process doing something slightly different, which may be argued to go against certain elements of certainly what was being argued by the development industry in this case. So yeah, a really interesting point about the politics of the judiciary, the extent to which, at this level certainly, points of high policy have quite an important bearing on the guidance that the court gives for such points. A broader canvas than just simply the issues in the case.
Yeah, very much that. I mean, you can see that by the interveners who were given permission to intervene, weren't they? You had submissions coming in from the HBF, from the Office for Environmental Protection, from the Wildlife and Countryside Link. A broad range of opinions, the court clearly recognising that this was going to be an important judgment, one way or another. Thank you very much indeed. Very kind of you to join me.
Thank you.
Thank you.
There we have it, an extremely interesting judgment with a lot of different threads on which to pull. Certainly a victory for CG Fry themselves, getting the appeal decision quashed on the basis of the error of law. Whether it's a wider victory for the development industry is perhaps a little bit less clear. The Supreme Court remaining steadfast in the conclusions reached by the lower courts that an appropriate assessment can be required at discharge of conditions stage, which will no doubt be a concern for some schemes. And while there was light at the end of the tunnel for CG Fry, this was perhaps a relatively unusual scheme in which we have concern about a Ramsar site, but not a European site. And it was really on that basis only that they were able to succeed. Similarly, whether it's a wider victory for those seeking to protect Ramsar sites and European sites is also a little less clear. Certainly in the short term, but the government has made no secret of its desire to rebalance the protection of the environment with the need to bring forward development. And we see that reflected in some of the clauses of the bill already, which we are expecting to get royal assent within the next few months. So stay tuned to the podcast in the coming weeks, where we will have plenty more to offer, no doubt on the planning and infrastructure bill, from the courts and from the industry at large.